Can you hear me okay?
Can.
Beautiful. All right. While we wait for some people to trickle in, Sean, how's your day going so far?
It's been great. No complaints. It's my anniversary, which is nice. So
Your
that's good.
anniversary.
Yeah.
What a fitting day to host a webinar about prenups and cohabitation agreements.
That's exactly why we planned it for today. How's your day going, Ryan?
My day's going pretty well, thanks. It's sunny and somewhat warm, so that's an improvement over 99% of 2025 so far.
Yeah. I guess the benefit and the drawback is my grass is growing really well, but it just means that I have to mow my lawn a lot more than I expected.
Such an adult.
Yeah, well, I guess it's the things we have to think about.
Yeah, exactly. Awesome. For those who are just rolling in, we're just waiting 1 or 2 more minutes before we get started on our conversation today about prenups and prenups, cohabitation agreements, and what you need to know before moving in with a partner. So we'll be getting started any minute now. Okay. Sean, it's 1:03. Why don't we start diving in?
Sounds good. Let's do it.
Awesome. Okay. As I mentioned a second ago, today's topic is prenups, prenuptial agreements, marriage contracts, and cohabitation agreements. What are they? What do you need to know about these types of documents? What do you need to know about the law before you consider moving in with your spouse? I'm Ryan Osborne. I'm joined today with my my law partner, Sean Valentine. We are both family law lawyers, mediators, collaborative practitioners. We work on these types of agreements all the time. We really like them, so we're really excited to be chatting about them today. So thanks for joining me, Sean. Um, so what's the answer to the question? What do you need to know? I think that can probably be summarized in a single answer, and I think you need to know what the law is, how that applies to your situation, and therefore whether creating an agreement like this for you and your partner, your spouse, is the right thing to do. So we'll talk a lot about the different considerations that go into making that decision to basically help decide, should I get an agreement like this or not? So before we can get into that, Sean, maybe you can start by telling us a little bit about the background. What are these agreements, and what are the differences between the different kinds of agreements?
And I do think it's important to recognize that the goal today is to really give you guys a lot of information, not to provide you necessarily with legal advice on specific situations, but general information. And really, we're gearing this towards people who are really looking to get these agreements done down the road. Not necessarily, the opportunity should be there so you can learn more about them and become educated, so you can go talk to somebody about them and draft them. To answer Ryan's question, the difference between a cohabitation agreement and what we call in Canada a marriage contract, which you generally know as a prenup, one of them usually is for common law spouses or people who are living together who are not married. And generally, a marriage contract or a prenup are for people who are going to look to get married, or they're going to be in a situation where they are doing a postnuptial, doing it after they're married. Some of the rights and responsibilities are different when we are looking at a common law relationship versus a married spouse. So you can kind of change the language a little bit in the different agreement depending on what you're doing. And what's really something that we need to think about too is there's always a big myth that these are for just really, really wealthy people, and you have to enter into them if you have millions of dollars in assets, but that's not necessarily the case. And I think that's something we'll talk about a bit more today too, because people are starting to get into relationships later and later in life, and they're starting to build up a little bit more net worth than they might have had when they were younger. And these contracts are really great for helping with that and kind of creating a situation where you're planning your future together, removing that mistrust and having those discussions before you end up in a long-term relationship with somebody else.
Awesome. I love that. Jump in, do the lawyer thing. This isn't legal advice. We're not your lawyers. This is just general information. Love that. Yeah, absolutely. These are essentially what I'm hearing, Sean, is these are the very similar types of agreements with different titles, and they might apply a little bit differently, or the law might apply a little bit differently depending on whether you're married, whether you're just moving in together. So it's appropriate to take that sort of context into account when you're making these agreements or having these conversations.
Yeah, and what's interesting about a cohab, it can turn into a prenup, right? It can be a cohabitation agreement that can then also become a marriage contract. You can, if you have that anticipation to think about moving forward long term, sometimes a lawyer can draft the agreement to cover both areas or both potential scenarios.
Right. So maybe just do one agreement potentially. Have it apply for the time that you cohabit and live together as unmarried spouses, but then have it continue on even after you're married. Have you also seen cases where people will do an agreement that they only want to last during the period of cohabitation, and then the plan is, hey, if we get married, we'll do another agreement then?
Yeah, we definitely have that all the time. I think Ryan and I both draft agreements like that, where they might have a clause where it stops after a certain amount of years, or right at the date of marriage, they say, you know what, we're going to end this one and enter into a new contract that outlines different rights and obligations at that time as well. Or some people simply just want it to protect their cohabitation period, and then they go on and not necessarily renew that contract, and they let the family law apply. That's in Ontario.
Right. So for some people, they feel a little bit differently about being common law versus being married, and maybe they want a different set of rules to apply depending on what if they break up while they're common law or versus if they break up later on when they're married spouses. Well,
I think people have very different situations, and I think the goal is to cater those agreements to those people and what their needs are. And you just need to listen to them and really craft an agreement that's going to fit the two people that are coming together, to draft that agreement.
such a great point. The law is the law. So someone wrote it, and it applies to everybody. There can be some, gray area or differences in interpretation, but it's there. Whereas with these sorts of agreements, people can literally sort of do whatever they want within certain confines, and as long as you can come up with it, we can probably find a way to write it. So this is a much more sort of intentional type of exercise in saying, hey, we want these rules to apply to us, not rules that someone else wrote.
Yeah, I agree. And honestly, Ryan, speaking of the law, why don't you take the next one, and why don't we just explain a little bit how the Family Law Act in Ontario, and I guess the Divorce Act a little bit too, can apply to married and non-married spouses if you were to not get into one of these contracts, just as a baseline so people can understand what their rights and obligations would be without a contract.
Awesome. Perfect place to start. I think that you really said it well. When we decide what to do with these agreements, we ought to be comparing sort of our thoughts and ideas, our goals against what the law already says. The law might already provide for a system of dividing assets, of paying support, whatever the case might be, that works for you, in which case, amazing. Maybe you don't need to spend the money on preparing an agreement. But first of all, if that's not the case, you need to understand, well, how does the law apply to my situation? And so when we talk about how does the law apply to my situation, we're only really talking about a couple handfuls or buckets of legal issues. When I say legal issues, I don't mean like areas of dispute or problems. I just mean matters that the law addresses, right? So to think about what goes into an agreement at the beginning of a relationship, like what we're talking about, we need to think about how the law applies to what happens when you are leaving a relationship. Right. So there are a couple things that we typically deal with. So kids, child support, spousal support, and division of assets. We're pretty limited in terms of what we can do with respect to kids and child support in these sorts of agreements. The law is very clear that those decisions have to be reserved for, many of those decisions have to be reserved for the time of separation because they're based on the best interests of the children at that time. So you can't say now the kids will live with me if we separate, and then what happens if in the time between now and then you become incapable, God forbid you have an illness or something like that. So we can't get into those things. That really leaves us with financial issues, right? So spousal support and division of assets, right? So the first question people are often curious about is, well, when do I have to pay spousal support? Right? Why and when would I ever have to pay spousal support? We're not common law, or we are common law. Funny thing about that expression common law is it sort of means different things depending on the context, right? Some people say, well, it's 3 years. Well, sometimes it's 1 year. Sometimes it's less than 1 year. It really does depend. So for spousal support to be payable, you have to meet the definition of spouse depending on what that is in your circumstance. It can be a period of cohabitation. So we've lived together for 3 years. But it can also be less if you have a child together and you live together and you're in a relationship of some permanence. So there's some flexibility there. When do we become spouses? It's a bit of a floating question. There's a case that was decided a couple of years ago where people who never actually formally lived together were held to be spouses and to have cohabitated because they basically did a lot of overnights over the course of 10, 12 years. And they acted as though they were spouses. Right, so it's a bit of a floating target, so it's important to get some advice on whether you and your spouse or whether you and your partner have reached that formal definition of spouse for the purposes of determining whether there might be a support obligation. So first off, is there a potential obligation there? I don't have a potential obligation to Sean because Sean's not my spouse, right? We don't live together, right? We might be work spouses, but we're not romantic spouses. So it's the same as any unknown person. If we don't live together, why would I necessarily have an obligation to you? So first thing to figure that out. So if you meet that definition, there might be an obligation to pay spousal support in the event of a separation. Spousal support, in my opinion, is one of the most challenging areas of the law. A lot of nuance. We figure out, first of all, entitlement. Next, we figure out what the amount might look like, and that depends on the differences in your income. And the law says, well, should you have this much of a difference, or this much, or this much, or this much, to the point where the person receiving actually has more money at the end of the day. It's a lot of different situations, but the point is, it's a payment to help the recipient become financially independent after the breakdown of a relationship. So it can apply if you are spouses. So if you have kids and you live together, or in most cases, if you've lived together for more than 3 years, does not matter if you are married or not married. If you're married, you become a spouse right away. I guess that matters. But either way, the law of spousal support applies equally to married spouses and unmarried spouses. You might want that to apply to you, in which case you deal with that later, right? You don't have to do anything about that now in an agreement. Or you might not want that to apply to your situation, in which case you can create your own terms about spousal support. So I said the law has these this entitlement language about period of time, or if you have a child, or if you're married, you can come up with your own arrangements for entitlement, for example, in an agreement like this. So first of all, know that that exists and when you might be entitled to either receive it or obligated to pay it in the future. Decide if that's right for you or if something else is right for you, right? The next big sort of issue is the division of assets. So how does the division of assets work? Typically, if you are, not typically, but the starting point for common law spouses is there's no division of assets. If you own it, it's yours. If you own it together, you split it. That's kind of the starting point. If my name's on title, it's mine. But historically, that can sometimes lead to some unfair outcomes. So what if we live together and we never get married and the house is in my name, but you pay all the mortgage for 20 years? It might be a little bit unfair for you to not get anything out of that house. So even though the family law act doesn't say, hey, you get this, what the common law, which is a fancy word for all the fancy term for all the cases that judges have decided in the past, common law might entitle you to something. You can claim an interest, what we call a beneficial interest in that house or that property or whatever. you might not want that to happen. You might not want to have the opportunity for each other to claim things against your various assets. So you need to know that these rights could arise in this situation and decide if that's okay, or if you want to opt out of that, do something different. Okay. For married couples, it's a little bit different. The family law spells out a formula for how to equalize. That's kind of a special word, how to equalize your net family property. That's another special word or term. Essentially, you share the profits of the marriage. So if you gained money during the marriage, even if you kept it in your name, even if it was from your job, your investing or whatever, the idea is that that money is to be shared with the other person. Lots of exceptions to that, lots of nuance and exceptions to the exceptions, but that's the general principle. You share the spoils of marriage. So what flows from that is, okay, well, if I came into the marriage with something, then I get to keep it. Yes, most of the time, depending on what that item is and what you do with it over the years. So common situation, I own a house already, I get married, my spouse moves in. The thinking is, well, that's my house, I should get a deduction or I should get credit for the value of the house on the date of marriage. Not so. The law says that's a date of marriage, or sorry, the law says that's a matrimonial home, you lose that credit. Do you want that to happen? Do you not want that to happen? And you got to think about, you got to know about this and how the law is going to deal with your house, your investments, whatever else you might share with the other person, so that you can make that decision about whether you want that to apply or not. So that was like 2 months of the family law course in like 40 seconds, or I hope it made some sense. But essentially, that's what a lawyer would go through with somebody when they're considering getting one of these agreements. Tell me about your situation. Okay, here's how the law would apply. Do you want to do something different, basically?
Yeah, what are interesting ones that people sometimes don't think about are the contributions to a property when you either don't own it or you're living even with parents, multi-generational homes and stuff like that too. And what you're saying in terms of the contributions towards renovations or towards mortgage payments, bills, utilities, things like that. That's sometimes often forgotten. And I think that that's an interesting one that kind of gets raised too. And when you're talking about your contributions, especially from a common law relationship aspect, or even as a married spouse, the protections in some of these contracts would help with you to try to define and narrow what those contributions would value and what kind of return you potentially could get for those contributions.
Yeah, I mean, you make a great a point bringing that up, and the point is that often there is an assumption about how these things, and in this case, these contributions, will be handled. And if the two people make different assumptions and they later separate, then that's where you have a dispute and a problem and legal expenses, right? So is the assumption that money is like rent? So it's sort of a contribution, you're not expected to get it back, or is the assumption that contribution is towards gaining an interest or building some equity together, in that house? And it's a good idea to talk about it sooner rather than later, ideally at the front end of things, so you can make these decisions consciously going forward.
Yep, I agree.
Awesome. So that's the law. We know sort of how the law might apply to a situation, but why would people want to deviate from the law? What are sort of some of the common reasons, Sean, that we're seeing where people are saying, no, I need to do something different than that because of situation X, Y, Z?
Mm-hmm. I think a lot of the people that come to talk to us are motivated by excuse me, some type of family gift or some type of large asset that might have been within the family. And what I mean by that is, mom and dad are helping with the down payment to a house, and they want to protect that down payment when they're making that purchase to ensure that if something was to happen, they would get that money back, or it wouldn't be lost in the matrimonial home, like you alluded to previously in our last question, because the matrimonial home does have very special treatment, right? And if you don't have some type of contract or some type of debt instrument that's on the property that shows it was actually a loan or some type of gift, then the presumption at law is that it goes away, that it kind of is involved in the actual value of the house and would be potentially capable of being split and part of the net family property assessment that we have. And sometimes as well, you could be a beneficiary of a trust or something, or there is a big family business or a farm or something like that, where you know it's going to get passed down and there's going to be some generational wealth that might come that way as well. And we're safeguarding that as well. We're ensuring that if there was a breakdown in the relationship, that interest, whether it's beneficial, contingent, or real at this time or materialized, doesn't actually form part of your net property as well. What's interesting that what the Family Law Act really does say is it is about contingent assets as well. And what we mean by that is it doesn't actually have to crystallize right now. We are looking at potential assets that you could get in the future. So a trust that you're a beneficiary of that you're not actually getting any money from could still actually be an asset to divide at separation. So some of those things are interesting to safeguard from. Other people will think about if they're bringing in an asset into the relationship, right? They own a house now. They have a large pension. They have something that they want to protect in case something happens in the future as well. We want to safeguard that because there might be a power imbalance in terms of financials where that person's bringing in a very large asset and the other spouse maybe doesn't have as much of a net worth. And in case there is a separation, they want to make sure that that asset is actually being protected or even defined, right? Sometimes we look at saying, well, we're okay with the growth of this asset, but I want to protect the asset up until the date of marriage. And let's crystallize that value and just say, we know that it's worth this, and we're really only going to work on the growth in the asset. We do that sometimes with houses, right? That someone brings into the relationship and we say, listen, we know that the house is worth $1 million today. I'm fine in sharing on the growth moving forward, but I want that first $1 million to be credited to me first before we share in that value, that growth over time. So that's certainly from an asset perspective, that's how you can manage things. On the support side of things, it's really interesting because you can define and create scenarios of spousal support depending on differences in incomes. And what I mean by that is you can create circumstances that still apply and still are within the confines of the law and the objectives of the Divorce Act and the Family Law Act. But you can create scenarios that better fit your current lifestyles and what the relationship could look like moving forward. And what I mean by that is you can create tranches of spousal support. You could define how income is going to be calculated moving forward, what types of income might be calculated, going back to that potential trust, that there could be some passive income or some dividends coming out of that trust that gets paid. We maybe exclude that. So we say, it's only going to be your employment income that were factored in because it might not be a fair assumption on what the value is. And it really helps to, obviously, hopefully protect someone who might be the lower income earner to guarantee some type of outcome versus having to think about what it could look like at separation and then fighting about it or having discussions about it. You'll be able to have a blueprint of what's going to happen over a certain amount of years or so you can manage the expectations and budget accordingly, knowing what that spousal support analysis could look like versus it kind of being rather gray. Because I think Ryan and I, you can probably agree with me, spousal support is probably the most gray area when it comes to family law. I think there's a lot of factors that go into it, and there's a lot of concerns of for people who are going through that process of what that's going to look like both on the recipient end and on the payor end. And so if you can find a way to define it or to clarify it ahead of time, people really like that because it does offer up some clarity and allows them to budget versus pretty much opening up Pandora's box and not entirely knowing exactly what's going to happen at that time of separation.
Right. So it sounds like it can go both ways. I mean, we talk about it sort of protecting the assets of the person who has assets or the income of the person who makes more. But I mean, you mentioned you're also seeing cases where you're guaranteeing some outcomes for the lower income earning spouse, so they know that they'll be taken care of as well. So there can be some give and take both ways.
Yeah, I think the best plan is to be collaborative on these, right? And making sure that
Right.
they are even. The ones that withstand judicial scrutiny, if they were to be challenged down the road, are the ones that are pretty narrow in scope, and on top of that, fair. They're not
Right.
one-sided, they're not disadvantaging one spouse from the other. They're really making sure that both people are protected, to ensure that the objectives, like I said, are being met. Because judges still have discretion to invalidate these down the road if they are not
Right.
fair, especially the spousal support side of things, right?
Yeah.
There's a lot of latitude to be able to do that. So we really want to be as even-handed as we can be to make these contracts withstand this test of time, and also be there to rely upon down the road if something was to happen.
Right. Yeah. That makes a lot of sense. So there's some certainty that we're after here. You mentioned an issue with loans, right? So there are a couple different ways to maybe protect loans from family. But have you seen cases where uh, one of the spouses contests that, oh, the loan was forgiven, or it wasn't actually a loan, or it was all done in good faith handshake deal at the time, on the understanding that it would be paid back and it would be credit, but then down the road, it's like, well, there's no paperwork. I want my interest in that. So, are you seeing sort of the usefulness of, even though you've papered a loan to try to protect this amount, probably best to talk about it and put it into an agreement to make absolutely sure.
Yeah, the marriage contract or the cohab agreement for this is probably the best way to do it, because both people have negotiated this, they've talked about it, they've hopefully had a lawyer review it with them and talk to them about it. It really helps the conversation and really helps with the validity of it. Because there could be a situation where only one spouse owns the matrimonial home, and they weren't a spouse before, and they got the gift. There's a mortgage that got placed on title, and the other spouse had no idea about it, right? Because it was either brought into the relationship and that was placed on there, or they weren't necessarily spouses before that ever happened. So it's a really interesting concept where we want them to be as familiar with everything, and part of that marriage contract negotiation is exchanging financial disclosure and becoming aware of all the
Right.
circumstances. So it really is the best way to offer up information to people, and to be able to withstand it. But there are other ways that you can go about it, but I wouldn't say they're the best strategy.
Right. So we talked about a bunch of the legal and financial reasons that people pursue these agreements, and we've started getting into, well, what else? What are the other considerations? What are maybe some of the more personal reasons? And it sounds like creating some of that finality for sure. Having a plan. Some people are just planners. They want to know. They have absolutely no intention of separating, but they just want to know that if God forbid it happens, then there's a plan. There's a plan in place. You also started talking about this joint effort, this exchange of information. You said financial disclosure, right? So when I talk about the benefits of these agreements, there's all the protecting money stuff for sure, but there's also the communication element that a lot of people value, uh, if not in the moment, because sometimes the conversations can be awkward and it's still somewhat a taboo thing to do, unless you're Gen Z, in which case it's apparently pretty normal these days. But for many other people, it's kind of an awkward thing to do. Um, uh, After the fact, a lot of people say, "Hey, this brought us closer together." Um, I didn't know, sort of, I didn't really understand their finances, and we're always kind of funny around money, and it was really helpful to sort of see and talk about these things. It was also really helpful to sort of talk about, like, hey, what do you want to happen? What do you care about? What are your values? Communication, certainly communication around money are some of the most common things that lead to the end of a relationship. So starting off a relationship uh, with um, uh, with those things, it seems like it really helps, and that's a lot of the feedback that we get. Funny enough, less fewer divorces amongst people who do a marriage contract. Um, I like to assume it's because they had these conversations, not because they're scared to leave, because the marriage contracts are bad for them. But anyway, so lots of reasons, lots of other reasons why people do these agreements. Sometimes they have a pet, and they, like as much as it's a shared pet and part of the family, they want to make sure that the pet comes with them. Sometimes they've just had bad experiences. Their parents had a really nasty divorce, and they just want to know that that's not going to happen with them, that there's a plan in place. Super common, second relationships, third relationships, whatever the case might be. Maybe you've already got children, um, or it's later in life. You want to make sure that you can adequately provide for your children without worrying that their inheritance is potentially going to be challenged by a former spouse or something like that, or a family cottage. You want to make sure it stays in the family, even though you might all use it together. So the reasons can be many. I started talking about how the conversation can sometimes be a bit taboo. So we thought we could share a little bit about how to have that conversation. First of all, expect that you might get a reaction. Um, there are different personal and cultural beliefs around these types of agreements. So I think prepare for the potential that someone might feel offended. And if that happens, then ideally you're preparing for this conversation with your therapist, with your journal, with your spiritual advisor, whoever, however you take care of yourself. But what I would suggest as a non-psychological expert is expect it, and if you think it's coming, and just practice active listening while it's happening. It's not an argument. It's just do your best to understand the feelings that are coming up for this other person. And that means listening. It's again not arguing. It's active listening means showing them that you understand. So if they tell you a story about their parents, then for example, you might say, "Oh wow, I didn't know that. It sounds like that divorce was really hard on you, and this conversation's bringing that up, and you might get it wrong, and you'll know because they might have another reaction, but you just keep trying, and at some point, they might feel understood. And when people feel understood, they calm down, and they're more physiologically capable of hearing your side of the story. So where are you coming from? So once you've validated that person's experience and helped them feel understood. Funny story. I was chatting with a client last week, and they were very upset about how the law did not recognize the really bad behavior of their spouse. And they're like, how could I possibly have to pay this person after all this? And I did two things. First of all, I called their spouse a dirty name. I don't know this person, but it sounds like they were worthy of the description. But what that did was show the person, look, I hear you. This is awful behavior. This is terrible. The law does a really bad job recognizing that. And like, funny enough, this was such an emotionally mature person. They stopped and said, "Oh, thank you. I feel better. I feel validated." And then I said, "So here's why you have to pay this much money." And they were able to hear that, like, okay, you know what, I get it. That's a good result if I can do that. Same thing. Help someone feel understood and then share your own experience. It's about a little bit about being vulnerable. So when I say that, I say focus on your goals, focus on your interests, what's important to you. Maybe it's the parents' divorce. Maybe it's, again, I'm a planner and I need you to know that. Maybe it's, again, wanting to protect my kids from my ex-spouse or something like that. There's a real human reason often behind the need to do these things. So those would be my top tips. Probably don't have your lawyer send a letter to the other person with a proposal, or maybe go to couples therapy or something. It's for everybody, even if you're not experiencing troubles in your relationship. So those would be my tips on how to start having that
Yeah.
conversation.
And just to let you guys know, if you do have any questions, there is a Q&A box that you can hit on the screen, and we have time at the end. We're happy to facilitate some questions and answer them for you. So feel free to send it to us in the Q&A or even in the chat function as well. And one thing I would highlight on top of that too, Ryan, is there are mediators like ourselves and other people that will mediate these contracts, right? And that could also be a great way to have those conversations and those dialogues about goals and interests. And it doesn't necessarily mean that you have to have it being one-sided. You can do this
Right.
collaboratively. And if there is that taboo element, why not approach the conversation, have a discussion, say, this is what I'm thinking about, and then maybe utilize the skills of a mediator to talk about those emotions and those thoughts and those things like that, because that is something that could be really helpful to sometimes bridge those awkward moments where it's just that one-on-one in the kitchen talking about it, or out on a date and slide
Yeah.
the contract over.
Yeah. In a public place with lots of witnesses.
Yeah.
Right.
Yeah, exactly.
Awesome.
So
Yeah.
those are, I think that's a great tool that you can utilize as well, without
Yeah.
putting your family, your friends in the middle. If it does get a bit awkward like that, you can use a mediator to
Yeah.
help you with that, and then also negotiating it.
That's a great point. There are a lot of people who do this sort of work who just want to help, and they're trained to facilitate conversations and communication. They're trained in active listening. They're trained in reframing, basically translating people's experiences so the other person can hear them. So that's a great point, Sean. So so far we've talked about the law, how it could apply to your situation. We've talked about common reasons why people do these agreements, both from a legal and financial perspective, and perhaps from an interpersonal or individual values-based perspective. So let's say somebody's gone through this and they've gotten to they've made the decision that, you know what, the application of the law doesn't work for me. I'd like to do something else. I don't know what that looks like, though. I just know that it maybe doesn't feel right to pay this or share that. I have some thoughts, but what next? Like, what are some solutions sort of look like? What are some frameworks or formulas or outlines for these types of agreements look like?
It depends on really what you want, but you can carve out certain exceptions, mainly again to deal with spousal support and property, and that includes maybe some debts as well. But from a property perspective, you can go from a narrow perspective to being much more broad. It really is going to depend on what you want. But some of the options and solutions that we have are you carve out one specific asset and say, this is no longer going to be divided between us, right? It's going to be my asset. We're excluding this entirely. We're not forming the part of the net family property. On that same asset, you could also say, you know what, I still want you to share in it. Excuse me. We're still going to remove this from the net family property, but let's define how we share this moving forward. And again, whether it's the growth in the asset, whether it's a return on our down payment first, and then we share in the growth. It's not going from like 0 to 100. We're carving up it and making a bit of an exclusion or an exception to that specific asset, but still growing it out. The other options you might have as well are, doing a blanket exclusion, basically saying that nothing is going to be divided whatsoever. We see this a bit more common in second or third relationships, or even like gray relationships where people are in their 50s, 60s, 70s. They have a lot of assets, but they're now entering into a second relationship, whether it be in common law or in remarriage. And I think that is sometimes the opportunity where they say, I want to protect my estate and I want to make sure that goes to my family. So we don't want it to necessarily be commingled. And so we draft these agreements to say, yes, we're going to share in this together right now. But if something was to happen, it's not going to form part of our net family property. And that also gives them the ability to marry if they really wanted to, without having to feel that pressure of the law applying to their scenario. And then, like I said, kind of previously, you can talk about date of marriage deductions and really just crystallizing what the value of an asset would be, or a debt on that day, a student loan as an example, or like an RSP or whatever have you, because sometimes that helps down the road if something was to happen, we at least have a paper trail of saying that the asset was worth or the debt was worth this amount of money on that day, versus 14 years later, 20 years later, you're trying to dig up a piece of paper for the worth of, you know, your $100,000 RSP or whatever at that time. So it at least helps you with that. And then some people are always concerned about debts, right? Liabilities and things like that. And sometimes we can safeguard against debts that might be owed going into the relationship, and saying, you know, despite this personal debt is going to be that specific individual's. It's not going to necessarily be mine anymore. And you can offer up some protection that way. So that's really from a property perspective. For spousal support, I talked about it a lot before, but, you know, again, to really rehash and re-summarize, and then Ryan, feel free to add in more, but you can define entitlement. So, you know, what would qualify you for spousal support moving forward? You can define how long spousal support might be paid for, whether it's, okay, you know, if you're together for 5 years, we'll pay you for 2, or if you're together for 30 years, we'll pay you for 15, or defining it like that. You can define the amounts that would be payable, you know, based on a percentage or based on a fixed amount. You know, when there's high net worth involved, sometimes we factor in fixed amounts per year of the relationship, and we find a way to make it work from a budget perspective and a needs perspective, understanding the lifestyle that they might have been going through the relationship, and making sure that, again, those objectives of self-sufficiency and recognizing that maybe one spouse will not work through the relationship, to offer them up that availability to kind of take the next steps and be economically safe. And then on top of that as well, again, you can define what's going to be income. You can carve out certain pieces of passive income if you wanted to say that that's not necessarily going to apply. You can add in what we like to call sunset clauses. So you could say, you know, this will apply for X number of years, but after that, the rules under the Family Law Act and the Divorce Act would apply for spousal support. There's a lot of flexibility that we can do with common solutions. Again, it's really going to be tailored to your needs, to fit your lifestyle and fit the potential risk of a separation down the road. You know, when we're looking at short relationships, that I would say agreements probably withstand scrutiny a little bit more when they're short, but it's really when you start getting into the longer relationships, 10, 20, 30, 40 years, that's when you start thinking about, okay, did we do enough planning at the initial stage of the contract to withstand that test of time? So much can happen. There's a lot of unforeseeable situations that could come up. Can we plan that appropriately? And that's where I find the delicateness of drafting and coming up with great solutions is more important, right? Like that is going to be the real proactive nature of this, is making sure that it can withstand the length of time versus the kind of the short immediate future.
Yeah. So you can get really creative. What is what I'm hearing from you, and what we see, right? So and that requires sort of understanding of everybody's situation economically, but also their values, what's important to them. So, for example, you know, if they separate in the first 5 years, well, you know, we're kind of more like we're more like early spouses at that point. So maybe not so much. But if we put in many years together, or if we have kids together, maybe we should treat that a little different. So we're having these conversations to understand how you value these different types of situations, and coming up with a custom plan, right? And you mentioned an important piece about sort of planning for the very distant future. I try to tell people, and I'd be curious to hear if you do the same. I try to tell people that this is great, but this might not be what you want as time goes on. What if one of you leaves the workforce? What if one of you gets sick? What if one of you gets a job in Australia and the other one follows them and can't work? Like, maybe you don't want these same rules to apply. So my advice is always like, hey, call me if there's a big change coming. Talk you through how the agreement applies to that change. And if it still works for you, fantastic. If it doesn't quite feel right, that's a great opportunity to have a conversation and what we call review the agreement, and possibly update it, because you can update these things whenever you want, right? I wouldn't suggest tearing them up if you ever want to get rid of it, because there's going to be virtual copies somewhere. But you can avoid them, you can edit them, you can change them, you can. So I think these are great points to for people to continue talking about this stuff as time goes on too.
Mhm. Yeah, and I think the last thing we can think about, and because I want to save a little bit of time for a couple of questions from the audience too, but what are some of the snags, or what are the things that might cause? Because we keep talking about standing the test of time and length. What are
Yeah.
some of the ideas, and what are the kind of the important things that we should think about if you're looking to get a cohab or a prenup agreement? What are the things that the audience should
Right.
know ahead of time, and timing, and things like that?
Right. So what does a process look like to make sure these documents actually accomplish your goal?
Yeah.
Right. That goal being, if I'm going to pay money and take the time to create an agreement or a contract, I want for that contract to be useful in the future. I don't want someone to be able to say, no, it's not binding anymore. So the process we recommend for that, and this will touch on some of the questions that have been popping up in the chat. First of all, ideally, you both have your own lawyers to provide independent legal advice. Okay. Even if one lawyer sort of does the initial upfront work of creating the draft and maybe giving some information to help the spouses have, or a couple have conversations, that's great. Get something on paper, then bring in another lawyer so that the other person can have their own independent legal advice. Call it whatever you want. Call it a sober second look. Call it someone in your corner advocating for you. At the end of the day, it's someone making sure you understand what you're getting into, what you're opting out of, what you're giving up or getting from this agreement. So getting independent legal advice and your own lawyer is always highly recommended. There's no law that says you have to. If you don't get a lawyer, it doesn't mean the agreement's going to automatically be set aside. But it's one of the most common ways that people try to set the agreement aside. And even the other spouse just trying to set it aside defeats the purpose of the agreement, because you've got to fight them. The point was to avoid fighting. So sucks, but sometimes it's worth spending a bit of money for them up front, another $1,000, another $1,500, or sometimes less, to get some independent legal advice. So everybody gets lawyers, ideally. Then typically we exchange financial disclosure. What does that mean? It's a summary of basically how much you earn, how much you have, how much you owe, right? It's great to make an agreement that I don't want spousal support from my partner. It's something very different to say, I don't want spousal support from my partner, and I know they make $1 million a year, and I would have gotten a couple $100,000 a year in spousal support if, after 10 years, right? The idea is great, but sometimes it changes with the reality. Sean, I'm sure this happens to you all the time. People call us, they say, we've already negotiated the terms for our separation. We just want you to write it up. I'll say, okay, cool, I'll write it up. Also, here's how the law applies to your pension. You're getting about $700,000 less than if you'd sort of followed the family law. Okay, well, now their minds have changed, right? So it's making that informed decision.
Yeah.
It's like you don't say, sure, doctor, give me the surgery without understanding what they're going to do and the risks, right? So you exchange financial disclosure. Ideally, we have some conversations about the terms before you write up the agreement, right? Sometimes I get these agreements, lawyers have written them up, spouses haven't even spoken, and there's no agreement, there's no consensus on what they each want. So ideally, have some conversations before you start putting words on paper. And at the end of the day, if everyone confirms that they're content with the agreement and the lawyer is satisfied that they understand the difference between what they would have gotten or would have had to pay under the law versus the terms of the contract say, then I'm going to be satisfied that this person knows what they're doing. They're making their own decision. I don't judge them. I don't tell them what to do. I just make sure that if they're giving up money, they know how much money they're giving up and that they're cool with that decision. So again, informed information. That's the key to this, whether it's financial disclosure or legal advice. One of the other ways that people can try to challenge these agreements is by saying they were forced into this. Maybe they were threatened. Their spouse said, sign this or else. Sign this or I won't marry you. Sign this or I'll hurt you. Things like that. Sign this or I'll make sure that you can't come to this country, lots of reasons. Lots of different ways that people can threaten each other. Another, we call that duress. So they were under duress. They didn't freely decide this. They had to make this decision. So obviously, ideally, you get a lawyer, and the lawyer can identify these things and give you proper advice and maybe get you some help. Another common form of duress is time pressure. I'm getting married on Saturday and I need to sign this document beforehand. I don't have time to edit it or negotiate it or learn my rights or anything like that. I just need to sign it. And then a few years later, oh my God, I didn't know what I signed. Right, so we want to avoid those sorts of situations. So ideally, we've got lots of time to complete these agreements before a wedding. If we don't sign it before the wedding, that's totally fine. Like Sean said, you can do a post-nup, still a marriage contract, still binding. Just do it after you get married, and then it's going to be even more. It's going to be even stronger. People can't. What we want to try to do is reduce the opportunities for people to challenge the agreement in the future. Okay. So that leads to a couple of the questions that we've had. Basically, can you do this before you move in, or after you move in, or before marriage, or after? You can do it at any time during the course of your relationship. Ideally, you follow these other steps. Get a lawyer, negotiate it without stress or duress, and sign it. The difference is that the law is going to apply a little bit differently. So if you've never moved in together, if you've never lived together, then maybe the law says you have no entitlements right now. So you're not technically giving anything up right now. So that's a different decision for a person to make than if they've been living together for a number of years or they've been married for a number of years. Then the comparison between the agreement and the law is, hey, I've been living with this person. I already have an interest or a claim potentially to this, source of income or asset. Do I want to give that up? So it's the application of the law that changes, and that can change the nature of the decision-making process. But you can do the agreement whenever you want. During the course of your relationship.
Yeah, another question we're getting a lot here too is, what happens if your spouse opposes this or doesn't really want to participate, and whether they don't get a lawyer or they don't do the financial disclosure piece. To start off, I would say there are lawyers out there that will do limited scope services, and what I mean by that is you can retain a lawyer to simply provide them independent legal advice on the terms of the contract. And I think that is at a minimum a really great step. If there's a lack of willingness to kind of participate, they at least will be able to give them an overview of the agreement that maybe you got prepared with your lawyer, and give them, again, that opportunity to understand what their rights and obligations are inside that contract. And that at bare minimum will help encourage them to understand it, and maybe will also, again, help with the validity of the agreement. Financial disclosure and ILA, like Ryan said, that doesn't automatically invalidate an agreement, but it is certainly a recommendation that we always give because it strengthens the agreement substantially, right? Those are always kind of the two checklists that a judge will look at to talk about if they're going to invalidate in court. They say, well, did they get ILA? Did they do financial disclosure? Did they have a lawyer, negotiating on their behalf? So those are really kind of the pillars that will help with the validity, but it doesn't on its face invalidate the agreement, especially if that person's sophisticated or has an understanding of what they're agreeing to, or that you've had conversations about it. So, it doesn't mean that you necessarily are handcuffed, but it is obviously a little bit of a concern just for the longevity of the agreement. So that's something you do need to think about. The one other thing I always recommend to people, and some people laugh at me when I say it, is, well, you don't have to get married. You don't have to move in with them. If that's going to be a situation where you are substantially concerned that your net worth might be affected, there's always the decision to either end the relationship, pause the relationship, go talk about this through therapy or counseling, or again, stay in a common law relationship versus being going and getting married. I think this really backtracks to those discussions that you need to have before you have these conversations about about moving in. Like that's why we always do say that it's usually best to get this discussion and this process done before you end up getting into living together or before you get married, because then you can be transparent about it, and then you can kind of know where you stand before the relationship starts to take the next steps. But that doesn't necessarily mean that you can't have those conversations afterwards. But I do think that, it shows an opportunity to be in alignment on what your future is going to look like by having that dialogue. And so one way or the other, I think that then you can judge and figure out whether this relationship is something that you want to continue long term just by having that conversation as well.
Yeah, it's classic dating advice. Good to know how everybody feels about everything sooner rather than later, so you can make that decision about the relationship. Right?
Yeah.
Okay, we're going to try to fit in a few more questions. There's a question about an agreement outside the Family Law Act.
No, go ahead. Yeah.
When separating and divorcing. In other words, have an agreement after the fact that they are separating. I think what this person is asking about is a separation agreement. It's another form of domestic contract that couples enter. So yes, you can create a separation agreement that does whatever you want it to do. You can opt into or out of the family law to whatever extent you choose. It just has to be mutual. That's what makes it an agreement. Right, so you can do that. It's just called a separation agreement. Okay.
Cost comes up too, right?
Sorry?
Cost questions, just, in terms
cost.
of
How much does this cost? Right. So it can be expensive. But we ideally try to keep costs as low as possible. So Sean and I are always having a conversation about budget with people. So things that impact cost are complexity of the financial disclosure and complexity of the terms of the agreement, as well as sort of the dynamic between the people. How much back and forth are we dealing with? So super streamlined agreement. I send you a form, you fill it out properly with your bank balances and your tax information. I don't have to do anything. Fantastic. We have a conversation about the terms. Ideally, all four of us, your spouse and the other lawyer. We have a conversation. We know what's going to go into the agreement. I write it up. There's minimal back and forth because we've already built consensus. We've already come up with the terms. We sit down for an hour max to review the terms, make sure you understand them, are happy with them. We meet separately to sign the agreement. It takes 5 minutes over Zoom. If you follow that process, we can do this for $2,000 or $2,500 all in, plus the cost of your partner's lawyer, which I mentioned earlier, might be another $1,000, $1,500, depending on complexity, depending on who you hire, where they practice, years practicing, those sorts of things. It can go up from there to a whole lot more if you want to do a really complex arrangement, and there's lots of back and forth. Maybe the communication is just a little bit different with that particular couple. Maybe one is works in the financial services industry, and having conversations about the spousal attribution tax rules is really easy thing for them. But the other spouse, it's different because their expertise is elsewhere. So there's just some extra work that goes into building those terms. And then the more custom they are, the longer it takes for a human lawyer to write them. ChatGPT is getting pretty good, but they also make stuff up. So hence why we still suggest working with a lawyer. So it's a straightforward agreement. It's within that range of $2,000 to $2,500. I know it's a lot. I paid a lawyer to do my wills recently, and I hated it. They were a friend, and they did a really great job. It's like insurance, like you pay for it, you don't get anything until your house burns down, right? So that's the idea: is maybe put a couple $1,000 into it now, and save tens or hundreds or more down the road. But every situation is unique, so reach out. We'll probably give you a quote.
Yeah, we always laugh when we say we hope that you file this away and it gets dust and we never ever have to use it down the road. But I agree with Ryan. It is an absolute protection and insurance, especially if you're looking at tens, hundreds, millions of dollars protecting assets, family wealth, things like that as well. So that's definitely something that you need to think about moving forward. Quite frankly, we hope you had a really informative dialogue and conversation with us about this. We really enjoy talking about this topic. I think Ryan and I really enjoy talking and engaging with people about marriage contracts and cohabitation agreements. It's a really great part of our practice because we get to see people on the front end of their relationships and start to have that collaborative conversation with another lawyer potentially, or with their partner if we're mediating them. And it really gives us some, great opportunities to engage in a great dialogue to draft and craft something that is going to be potentially a blueprint for your future together. If you do end up wanting to reach out to us to have a conversation about this, you can hit us up on our website or any of our social media. We will likely be sending out a link to this conversation afterwards to all the attendees, so they can always review some of the things that we talked about as well. And again, we're here if you do have any questions or want us to help you draft an agreement moving forward. We would be more than happy to assist you. So thank you so much for attending, and we wish you guys an absolute great rest of your week, and we look forward to hearing from you.
Awesome. Thanks so much, Sean. Have a great day, everybody.
Take care, everyone.